Welcome to this presentation by the Africa Institute for Personal Development. The importance of a last will and testament. Step 1. Let's recap. Let us start by reflecting on a few key learning points from the two presentations on estate planning basics. It dealt with the following topics amongst others. What is an estate? When a person dies, all his or her assets on the date of death will be placed in an estate, or commonly known as a deceased estate. In the legal sense, an estate refers to all the assets, entitlements, and liabilities that individuals have accumulated over their lifetime. What is estate planning? Estate planning is the process of making it clearly known how you want your estate to be handled after death, or if you become disabled, or incapacitated, or unable to handle things on your own. In other words, your estate plan maps out the process of administering and dispensing your estate. What is about death? The only thing from the future you can be sure about is death. The time is, however, never known to anyone. Key learning point. A properly prepared estate plan will lay out your wishes exactly in the most tax-advantaged manner, so you can trust there won't be any questions, misunderstandings, or misconceptions about what you want. Step 2. Objective of this presentation. In this presentation, we cover the importance of a last will and testament. There are many tools you can use to achieve your estate planning goals, but a last will and testament is probably the most vital. Note: if you are not convinced that you need a last will and testament and take appropriate action after this presentation, then you will have to look at another module entitled, "It is really a bad time to die without a will and estate plan." Step 3. Understanding the basics. A last will and testament is a legal document in which a person declares what you want to be done with your estate, namely, your assets and personal possession after your death. The creator of the last will and testament is called the testator or testatrix if female. The people who inherit the deceased person's estate are called the beneficiaries. A typical will name people, that is your surviving spouse, a child, other relatives, friends, or anyone you choose, or organizations, or a trust, or a charity. The beneficiaries are to receive the testator's assets and belongings in a manner and amount specified. The will can also appoint an executor, a personal representative, or administrator. His or her responsibility is to settle the testator's estate to the terms of the will and carry out estate planning tasks such as locating your will, collecting your assets, paying legitimate creditor claims, paying any taxes owed by your estate, distributing any remaining assets to your beneficiaries. Other provisions in a will. A will may include other provisions which are either required by law or are important to the testator. For example, the nomination of an executor, personal representative, or administrator. It can describe the powers and responsibilities of the executor. A will may also specify the testator's wishes with regard to funeral arrangements, organ donations, guardians for minor children, trusts to be established and funded after death, or a living trust that can create during your lifetime. Will avoid intestacy. Dying intestate, that is, without a will in place, the government's intestate succession laws comes into effect. Firstly, the government will provide a will for you. This intestate will appoints an executor or administrator for your estate, distributes your estate in general terms to your closest blood relatives in proportions dictated by law. However, the government's distribution may not be what you would have wanted. There could be serious disputes amongst family members over your estate that can devastate the peace and happiness you've always sought for your family. Will provisions can be challenged in court. Although it does not happen often, the validity of your will can be challenged, usually by an unhappy beneficiary or a disinherited heir. Some common claims include: you lacked testamentary capacity when you signed the will, you were unduly influenced when you drew up the will was forged, or the will was improperly executed. Do you need a lawyer to write a will? Obtaining professional advice when executing a will is not a legal necessity. However, be aware that a last will and testament must meet certain requirements as provided by law in order to be valid. In an event, once you have all of your information in order, you can either hire a lawyer or estate planning specialist that will provide you with some legal guidance. What should you do after you execute a valid will? Firstly, you should let people, such as loved ones and or your lawyer or estate master, know where the will is located. You should also remember that periodically update your will to make sure it reflects your current life circumstances, namely your marriage, divorce, births, etc. In conclusion, death is a certainty. Each person should spend time drafting an estate plan and ultimately a last will and testament that caters to their unique circumstances. A last will and testament is the cornerstone of estate planning. It can give you great peace of mind and make things easier on your loved ones left behind. To find out how these ideas relate to your unique situation, and to learn more about how to protect yourself and your loved ones, call or email Estate Master to schedule your no-cost, no-obligation virtual consultation. Your Estate Master will empower you before death, at death, and after death.